Good Sunday to you. Welcome back. Fresh memories of the most contentious judicial nomination in memory. Activists gathering at the Supreme Court right now to mark the one-year anniversary of Brett Kavanaugh's confirmation as the 114th justice. That is a live look happening there now, all ahead of the High Court's new term kicking off tomorrow, the first Monday in October. A full docket awaits the 9-member court. Issues like immigration and executive power, LGBTQ rights in the workplace, abortion regulations, gun rights, all of this is going to be argued this term, with rulings expected by late June, right smack in the middle of a presidential election year. Here with a preview is our stellar legal panel. Using that word, stellar. Judicial Crisis Network Chief Counsel and Policy Director Carrie Severino and Constitutional Accountability Center President Elizabeth Wydra. Thank you both for being here. Let's start off with workplace discrimination when it pertains to LGBTQ. Two cases going to be heard together. Both claim that they were fired because they were gay. There's a transgender case as well. Carrie, I'll start with you. What do you see happening with this?
I think what's so interesting is this, and we see this in other cases this term as well, where both sides are really trying to claim the mantle of textualism or originalism, saying, no, our meaning is the first original meaning. I think in this case, it's going to be a real challenge to do so because the words because of sex, I think it very clearly at 1965, it was clear what they meant. They meant because of sex specifically, and there's a distinction between discriminating someone on the basis of sex. So say if you fired someone who is a gay man but not a lesbian woman, that would be discrimination on the basis of sex. In this case, the question is not, is it a good idea to add this to the law, but is it the court the right person, the right entity to do it? And obviously, that's something that should be reserved for the legislature. If we're changing it, I think it's pretty clear this would be a change.
What do you say, Elizabeth?
Yeah, so we filed a brief on behalf of textualist scholars who say, you know, the law says, what Congress passed says because of sex. Now, if I am a person who's attracted to a person of the same sex, that's because of sex if you fire me because of that. Or if I present and identify as a gender different than the one from which I was assigned at birth, then that's because of sex. So, you know, it's really just about the words that Congress passed and applying them equally to our LGBTQ colleagues, coworkers, and neighbors.
Okay, let's move on to the next, which is immigration and executive power. And this is stemming from the process of trying to phase out DACA. So, Elizabeth, I'll start with you on this one. Where do you see this going?
Yeah, so this is a real interesting case for, I think, particularly the Chief Justice, because, you know, certainly presidents have the discretion in immigration areas like this, you know, but President Trump put forth this, you know, in my opinion, a bogus pretext that he had to withdraw DACA because it was unlawful. Not because he thought it was bad policy, but because it was unlawful. But that is not true. It is actually a lawful use of executive enforcement and immigration. But he knows that DACA is incredibly popular and that hundreds of thousands of dreamers are parts of our communities and valued by this country. So he wants the Chief Justice and the Supreme Court to do the dirty work for him and say his hands are tied. But that's not true. So the question is whether the court will see this as the bogus pretext it is, like they did in the census case, or whether they'll go along with the president as they did in the travel ban case.
Let's go to Carrie. Do you agree?
I agree. I think this is going to be, I will see if they go like they did with the travel ban and said it's not appropriate to look behind what the actual action being taken is, because I think everyone can agree that what the president can make these regulations, he can change the regulation. That's within the executive's authority. It's really, are they going to treat President Trump differently than they would any other president by saying, no, we're going to try to second guess what he's doing? I think that that's a real problem we've seen in the courts, and we'll see whether the Supreme Court decides to go
watch, that's for sure, and be curious to see how the outcome of that then plays into what goes on in 2020. Of course, the outcome of all of these. Let's move on to gun rights right now. This is specifically a case in New York State, in New York City. Law regulates where licensed gun owners can take locked and unloaded handguns. Now, this is kind of moot at this point because the city then went back and revised the law, but it's still something that's going to be heard in the Supreme Court. And Carrie, you were making a point about this in the commercial break, that you think this is really important.
Yeah, it's not just the case itself, which is significant. The question is it really completely moot? But because of a brief that was filed by Senator Whitehouse, joined by several other Democratic senators, that more or less threatened the court in very thinly veiled language, saying if you don't rule our way, if you don't dismiss it as moot, then we may have to restructure the court. He's alluding to proposals to pack the court. That's something that even Justice Ginsburg has said would be boldly political and inappropriate. But I think it's worrisome because it's part of a pattern pattern of intimidation against the court and threats to judicial independence that I think the court's going to want to reject.
We have under a minute. We want to get to abortion regulations. So, Elizabeth, I'll go to you with this for now. This is Louisiana, obviously going to be a big one, challenging a Louisiana statute requiring doctors performing abortions to have admitting privileges at a nearby hospital. You even said this is going to be a big one to watch.
Absolutely, because the Supreme Court in just 2016 struck down an identical law from Texas. So, you know, there's been this change in the court, obviously, with these new Trump justices. So the question is, in just such a short amount of time, will the important right to choose and access an abortion be whittled down to such an extent that it has no meaning? And again, in the context of an election year, whether or not the Supreme Court will strike down the right to have an abortion in just such a short amount of time after it upheld that right in the whole women's health case is going to be a huge, huge issue.
Well, we had a lot to talk about. We got through all of them, all the ones that we had on our list to talk about anyway. There's certainly going to be a lot of conversation surrounding all of these in the upcoming months and year. Carrie, Elizabeth, thank you for joining us. Appreciate it.
Great to be here.
Leland.